Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. I hope you've been following the series on giving you an introduction to the Constitution. I believe the way to achieve more justice in our society is through more learning. Our Constitution says, we the people of the United States. And then later it says, to ensure justice. So this series is designed to help us learn about the Constitution, and as a result, to bring at least another taste of justice. All interpretations here, all summaries are my own. But for informational purposes, I'm a professor at Mississippi College School of Law. Now, I haven't posted for a few weeks. I know you've missed me, right? And if you're not a subscriber, be sure to subscribe and sign up for notifications. But my students have been hard at work at Mississippi College School of Law. First, they had a take-home examination. They had a week to work on it. It was a doozy. And now I'm busy grading about 15 type pages each for all of my students. The next assignment they had is what we're going to look at today. The next assignment was they each had to prepare a position statement. Their statement had to be on a current constitutional conflict. They did a written 1 to 3 page statement, and now they're presenting them in class. They have 10 minutes to make their argument, and then we have some nice little questions for them. And if we don't get to all of my questions, I do follow-up emails to continue to engage with them. So today, what I'm going to do is I'm going to summarize some of the position statements that we heard on Wednesday in our first day of class on this assignment. But I want to point out all of the summaries are my own interpretations of what they said. So what I say here is not to be ascribed directly to my students, as maybe I misheard them. Now, in their position statement, they had to do several things. First, they had to identify something that was current. It had to relate to the Constitution. And there had to be a conflict, meaning people are fighting about it. But in 2020, people are fighting about lots of things, hopefully not physically fighting, but having debates about many constitutional issues. So they had lots to pick from. In the text below this video, I've given you the titles of the first 7 of these statements. And later I want you to go back and read each and determine if you agree with their positions or if you disagree. Now, their assignment had several things. First, they had to give the factual and the constitutional basis for whatever they were writing about. Secondly, as the good lawyers they planned to be and the good citizens, they had to consider the other side. Now, they knew what their position was, but they first had to write about the opposite position, the position they disagree with. As good lawyers and good citizens, we need to have understanding. And part of that understanding is to see the other side, even if our position is different. After they considered the competing position or the opposite position, then they made their argument for their own position, and they followed with a conclusion where they encouraged us to agree with them or to endorse their position. So at the bottom of the page, I have the 7 listed, and I'm just going to summarize them a bit and tell you what are some of the other issues I see there, and tell you a little bit about what their arguments were. Now, let me point out, for those of you in my classes, or those of you in class at another school, or in school in a college or high school or what have you, or in just all of our citizens who are here learning and getting a taste of justice. You know, these issues, there are so many issues to think about and analyze and read. So don't just hear something and say, that's my position, that's what they told me to say. Read it, explore it for yourself, and determine what are the various viewpoints, and then decide where you come down, right? So the first student, the very first presentation for today, that student's position is this: if the right to vote absentee is extended to one, it should be extended to all. The student believed that, the student was troubled that in the states, in terms of the presidential election coming up and other elections, that people who live in one place may be allowed to vote absentee. They may be allowed to vote maybe online. They may be allowed to vote by mail. But in some other places, individuals are not allowed to vote in that way. They may be allowed to vote absentee only if they are severely ill or have some type of disability. So this student said that if one person is being allowed to vote absentee, especially during these times, or allowed to vote by mail, then all of us as citizens in this country ought to be allowed to vote absentee too. She did an analysis under the Equal Protection Clause, which says that government may not treat similarly situated individuals unequally unless it meets the requisite level of review. This refers back to an earlier video I posted, What You're Talking About Government. You go back and you can see about that one. But basically, since a fundamental right is at issue, the fundamental right to vote that is stated in the Constitution several places, her argument is that government cannot treat us unequally unless it has a compelling interest and the unequal treatment is narrowly tailored. And here, what is that about? So she believes that nationally, we all should be allowed to vote absentee or vote by mail if some are being allowed to vote in this way. Now, I had a few follow-up questions for her, and I direct those questions to you. What if a state said, okay, what if the state said, we don't want everyone to be able to vote absentee, so no one can vote absentee? What if the state said, we don't care if you're going to be out of town. We don't care if you're in the military. What if the state said that? We don't care if you're sick. If you cannot come out to vote, then you cannot vote. Now, would that be constitutional? And you're saying, will the state do that? I hope not. But after Brown versus Board of Education, some states actually shut down their schools because they refused to operate their schools in line with Brown versus Board of Education. And they said, we just won't have schools at all. So that was the question I posed to her. If a state did that, would it be constitutional for a state to act in that way? She'll have her reply to me real soon. So I pose her question to you, and I ask you, do you agree with her position? Her position is that if the right to vote absentee is extended to one, it should be extended to us all, or the Constitution is being violated. She did a very good job in class. The second position statement that a student argued on Wednesday was also related to voting. Her position statement was this, and you can read again, all of these are typed in the bottom in the text beneath the video. This is her position. Former felons should be allowed to register to vote, even if they owe court fines and fees, because voting is a fundamental right under the Equal Protection Clause and the 24th Amendment of the Constitution. So she's looking at situations where a person is convicted of a felony, and then they have either served their time, and you may not know it, but some people take a plea bargain for a felony and they may not serve time at all. That may not be a part of the sentence. So we have a person who is now not incarcerated, but they are not being allowed to vote because they owe some court fines or some fees. And in some states, those individuals are not allowed to vote because they have not paid the fines. Her argument is that they should be allowed to vote and that this is in violation of the Equal Protection Clause. Do you agree with her? Now, she says that requiring a felon to pay a fine or fee, she agrees with that part. We do need the fines and the fees collected. She agrees with that. But she disagrees that the right to vote should be withheld until those fines and fees are paid in full. She says that requiring this payment to the court is like requiring a poll tax. And under the Constitution and prior to that in case law, the court said that poll taxes requiring people to pay money to be allowed to vote is unconstitutional. So now, one question I had for her, I had a couple of questions for her. One question was whether the requirement that you pay these fines before you can vote, is that in violation of the 8th Amendment against cruel and unusual punishment? And she didn't think it was. She just thought that it was, the government did not have a compelling governmental interest to require the payment before the person could be allowed to vote. Then my questions, I tried to take her on another path. I said, what if in a given state that all felonies do not lead to the loss of the right to vote? And I think that's correct. Not all felonies lead to a loss of one's right to vote. I said, what if you find that there are particular racial groups that lose their right to vote more because perhaps the felonies that cause a loss of the right to vote maybe are committed more by one group than another? What does she think about that? And this could really lead to some deeper research in terms of whether the structure of who gets to vote is more tightly connected with race or connected with economic disadvantage than we may see on the surface. So do you agree with her? Do you believe that a felon, a former felon, someone who is not incarcerated, but who has not paid all of their fines, do you believe that constitutionally they have the right to vote? You think on that and decide if you agree with her position. And she also did just a great job on her presentation. Oh, you see, I'm having so much fun with this. Now, my third student who presented, the student made this argument. If the president, okay, make sure I stay in line. Okay, yes, it's on voting too. If the president, is the president able to individually modify voting methods? Can the president simply execute some type of executive order and change the way we vote? The student's position is, his position is no. He said there is no precedent for a president having any influence in how an election can be decided. It has always belonged to the state and Congress. So in his position, he argues that if the president tries to, or any president tries to change the structure of how people can vote through executive order, that is unconstitutional. He says the right to vote that appears in the Constitution, modifications to that right have been pursuant to the authority of the states or the authority of Congress. And we know there have been many cases where the court reviewed this certain actions by the states or by Congress to determine whether those actions did violate the fundamental right to vote. Now, I had some questions for him too. Now, Ian, my question for him was, he says that a president has never taken steps that have affected the right to vote. So I asked him to send me some comments about Bush versus Gore. Do you remember the Bush versus Gore case from way back, where presidential candidate Bush brought a lawsuit wanting Florida to stop recounting its vote? You know, there ended up being another lawsuit brought by the NAACP. Those votes that they were trying to recount, perhaps those votes belonged to many individuals who were Black, and the NAACP case was ultimately settled with Florida agreeing to make certain changes. But let's go back to presidential candidate Bush. Now, how did he bring that lawsuit about the voting? How could he affect the voting process? Going back to one of the clips about justiciability and who can bring a lawsuit, how could he bring that lawsuit? He wasn't voting in Florida, but nevertheless, we know that the court did indeed rule in his favor. So here, my question to him, he said there was no precedent that that means nothing on the record that shows the president has this authority. But I asked him, how does Bush versus Gore figure in? Does Bush versus Gore implicitly give some type of authority to a presidential candidate to bring some type of suit, even if not the president himself? An important issue, an important constitutional conflict. And I can't wait to see what his response is. he did an amazing job too. We had a great day in class. Okay, now, the next statement that a student presented was about the Second Amendment right to bear arms. And you may say, why did I, a professor, right, include voting rights with the right to bear arms? You may say those are two different topics. Okay, I'm going to tell you why I did it. It seems to me that often, okay, let me start over. It seems to me that some people who argue for wide open First Amendment rights, wide open Second Amendment rights for themselves, do not always argue for wide open voting rights for others. And maybe those who argue for wide open voting rights do not embrace wide open Second Amendment rights. So I grouped these two topics together to see if there is some distinction. Where I wanted to see if my students felt more strongly about Second Amendment rights, if those students also feel strongly about voting rights. And if they don't, how do you reconcile this given that both rights are expressly stated in the Constitution? So anyway, my students' position was that the Second Amendment is a fundamental right. And as such, individuals should have the right to bear arms with only minor governmental restrictions. And any restrictions should be subjected to the most exacting level of review. Now, the student, and I think in an earlier clip, we talked about the Second Amendment, and in the two cases, the Supreme Court has decided, as of this taping, those cases involve the right to bear arms within one's home. And the court said that other limitations could be made. But it didn't say that we scrutinize those rights with the most exacting scrutiny if government intrudes. But this student, his argument was that Second Amendment rights are paramount. And when he replied to my question, I believe he argued that Second Amendment rights are entitled to perhaps even more protection than privacy rights and even more protection than voting rights. You see, privacy rights generally, but not always, are protected from the government unless the government can satisfy a high level of review. But sometimes a lower level of review. Voting rights ordinarily are protected from governmental restriction unless government satisfies a high level of review. But sometimes a lower level of review is used. So I said, well, what about the right to bear arms? Shouldn't they also be bifurcated in this way? But the student's response to my question was no. He said these rights to bear arms are critical to an ordered society. And he really believes that the Second Amendment should get more protection than the rights that receive this bifurcated, at times, approach. Fascinating. He also did a very good job in class, arguing his position and arguing the competing positions. So we had those four. Then we took a bit of a break and we went into looking at three more position statements that I'm going to summarize for you briefly. They were all related to the health pandemic that we're experiencing in 2020. So here was the student's statement. During a health pandemic, the state mandated facial mask requirements are constitutional, as they do not violate an individual's constitutional rights. And here, the student argued, she argued that no constitutional rights are absolute, and that government had a compelling governmental interest to require the face mask, and that the restriction was narrowly tailored. It was only for the duration to address the pandemic. Now, I had a question for her too. There's this case, Willie versus Maynard. And in that case, New Hampshire had a tag, car tag. The motto on the tag was live free or die. And a Jehovah's Witness covered over those words on her tag. She said that she did not want to speak that message. It was against her religious view. So the question I asked the student was, if the state requires an individual to wear a face mask for safety of us all, is the state requiring an individual to speak? And in that case, would an individual have a First Amendment right not to wear a mask? Now, she's already replied to my answer. She broke that answer apart and looked at it piece by piece. She said, no, because the face mask is for public safety, and that states and government may address issues for those reasons. Then she said, even if there is a speech right, or even if there is some type of integrity right, government may intrude on that right as long as government has a compelling governmental interest and the intrusion is narrowly tailored to that interest. So here she says, of course, government has a compelling governmental interest to require a face mask because it is for the safety of us all. And she also did a great job arguing both sides of the issue and supporting her position. Okay, two more. The next position statement, I had a student also related to COVID. Okay, let me find it here. And this was her argument. Stay-at-home orders should be deemed constitutional as they do not violate the fundamental right to travel or the Equal Protection Clause, so long as there are safeguard measures to ensure procedural due process. So she took a very interesting approach here. She was primarily looking at the city or the county within a state stay-at-home orders. She said that she's going to remove here the consideration of interstate travel. She wants to look at the local controls. And she made an argument that the right to travel locally ought to be considered differently than a right to interstate travel. Now, she said that these stay-at-home orders must satisfy procedural due process. So what is procedural due process? Okay, government under the 14th Amendment or the Fifth Amendment, if you're referring to the federal government, 14th for the states and the cities. Let me ask you this. Can government deprive you of your life or your liberty or your property? Under the Constitution, the answer is yes. The Constitution says that government can deprive you of your life, your liberty, and your property, but not without due process of law. So procedural due process, as she explained so very well in her presentation, refers to getting notice, having a hearing. My question is for her was, did government have to give the hearing before they put in place the stay-at-home order or after? It's called a pre-deprivation hearing for the con law folks, or a post-deprivation hearing. Which would be more appropriate here? And I continue to await that answer. Their deadline is coming up in a few hours. Can't wait to read their answers to my questions. You see, in class, I wanted to give the class, the other students, an opportunity to ask them some questions to push their classmates on their positions to disagree with them, but respectfully. And we managed to do so in the first class, to be respectful and professional in our disagreement. And so I tried to hold myself back because I would have just taken over the whole thing with my questions. And I did a follow-up email to them with my questions. So I'm waiting to hear from her in terms of what type of process did the local government owe to individuals for the stay-at-home orders? Did they have to have a hearing before or after if they believe their rights of procedural due process were denied? And she did a great job. All of them did. Okay, now my final one. So you may be saying, everybody is supporting government. You know, where is the diversity of position in the class? Well, here it goes. So I grouped this next position statement with those two to show the disagreement. And we had a very good discussion, and I've had some very good follow-up from the students. Okay, here's his position. He argued, the government is exercising so much control over a citizen's everyday life during the pandemic that they are violating due process by constructively depriving the liberty of the people. He did a very good job with his argument. He's saying that here the government cannot just make all of these demands on the people, that they're depriving the people of due process. And he also had some arguments, I believe, related to the Equal Protection Clause and how the government makes decisions. This person must stay at home, this person can go to work, this business must be closed, this business can be open, this operation cannot happen, it's not essential, this operation can't happen in a hospital. Now, here's my question I gave to him. He says that these orders, that what the government is doing to restrict individuals to try to get a handle on COVID, he believes is depriving individuals of their liberty. Now, as I listened to his very interesting presentation, I started to think about a case called Korematsu. I don't know if you remember that case, we talked about it. Korematsu, when Japanese citizens now, not non-citizens, they were citizens, people were afraid, and they placed them in internment camps and such. And the court upheld this. I mean, the case is now, most people do not like that case anymore. There's some debate as to whether it's overruled. The individuals who were affected received some reparations, but not total reparations for their losses. But there's a sentence in that opinion, Core Matsu. It says that as citizens, we always talk about our rights. We have some duties too. And the court said that these Japanese citizens, they had a duty to allow themselves to be placed in internment camps so that other people wouldn't be afraid. So I sent him a question asking him, does that case have any relevance to the position that disagrees with him? And then the fact that we don't like Komatsu anymore, is that a case that, does that help his position? But that sentence that the court entered, that as citizens, we all have rights, but we also have duties. That sentence has sort of stuck with me as I've read material over the years. So look, as you can tell, I'm having a great job, a great time. I'm so proud of my students as they're digging deeper into these constitutional issues. And they're analyzing issues that we're disagreeing about right now. And they're examining the Constitution to see how they believe it should come out. And they're debating with one another about their different points of view, but they're doing so respectfully and professionally. I want to congratulate my first 7 students on their very diligent work. They did great jobs. I'm not saying right now how I agree or how I disagree with them. That is not relevant to the exercise. What is relevant is they develop their position, they see the other side, and we engage one with the other in the classroom. Remember, I believe that learning about the Constitution is a path to justice, to the justice that is mentioned in the preamble to our Constitution. Learning and knowledge is a pathway to at least a taste of justice. I'll see you again next week, and I'm going to tell you about the next 7 position statements. Make sure you read those that are at the bottom and decide, debate with your friends and family and community which positions you agree with or disagree with. Subscribe and sign up for notifications. Join me again, A Taste of Justice with Professor Angela May Kupenda. Goodbye. Okay. Oops, I've got to figure out how to get my mouse to turn this off.